families facing medical child abuse allegations and have seen firsthand the trauma of when the system gets it wrong. As chair of the Human Services Committee, which oversees the CPS system, we know that child abuse is real. And there are really bad people who commit heinous crimes against children. We also see the devastation that occurs when the system gets it wrong and families are falsely accused and torn apart. We see these cases even more as we see an increase in medically fragile and chronically ill children, which has been a focus of mine and the MAHA Make America Healthy Again movement. In the case of Robert's daughter, Nikki, there was a rush to wrongfully remove life-sustaining treatment without proper consent or knowledge by her father, Robert, who was the only one with the legal right to do so, in violation of Nikki and Robert's rights. He was immediately suspected of child abuse with no alternative explanations investigated. And it was determined that his rights didn't matter, but that is not how due process or our legal system are supposed to work. This is both a parent's rights and pro-life issue. Often in child abuse cases, we see good people who work in the system and spend their careers witnessing horrific abuse against children come to see everyone through that lens, which is what happened in Robert's case and is still happening to this day. Because of these blinders, there was a lack of objectivity and a biased investigation throughout every part of this process, including his own publicly appointed trial attorney, who simply agreed with the prosecution that this was a classic shaken baby case. Brian Morton, the lead investigator who is now advocating for Robert, has admitted that their own bias kept them from investigating any alternatives other than he shook his child. These types of child abuse allegations still occur today, as does the rush to remove life-sustaining treatment from children by pressuring families or circumventing parents' rights. Nikki's life-sustaining treatment was withdrawn by family members who knew they didn't have the legal authority to consent, and without Robert's knowledge, while he sat in a jail cell without a criminal attorney to represent him and with his parental rights still intact. That should terrify every parent. Her diagnosis of shaken baby syndrome was rushed, and the autopsy was conducted without reviewing complete medical records and based on the presumption of abuse, while an investigator stood in the room telling the medical examiner about the shaken baby syndrome diagnosis and that the father had already been arrested. I and other members of the legislature have passed pro-life laws to protect patients' rights to life-sustaining treatment and guarantee due process for end-of-life and parental rights, including in cases of misdiagnosis of child abuse, but families still suffer the consequences of these wrongful and false diagnoses of abuse and attempts to withdraw life-sustaining treatment to this day. Robert deserves an unbiased and fair trial where all of the evidence, including exculpatory evidence that has never been presented to a jury, is weighed and considered. Our justice system demands due process and a fair trial. Robert had neither. We are all flawed humans, and our systems are no better than we are. Sometimes we get things wrong. But as a society, it is incumbent upon us to be part of the solution to improve our justice system. We are a country founded on liberty, and liberty requires a fair judicial process. Our country and our justice system depend on this. We have an opportunity to get this trial right, a fair trial, for Nikki, Robert, and any family who has been or may yet be facing accusations of child abuse. I'm going to turn it over to the advocates and families here today whose stories demonstrate that this is a very real problem that any family in Texas can face. We're going to start with John Sego with Texas Right to Life, who will share about their work helping families advocate for patients and families' rights around life-sustaining treatments, which is an important aspect of this case, and we will have time for questions in the end.
Thank you. My name is Dr. John Sego. I serve as the president of Texas Right to Life, and I'm a published bioethicist. I'm here today to draw attention to something that has been ignored generally in Texas and specifically in the discussion around this case: the unauthorized and hastened removal of life-sustaining treatment of hospitalized patients, including hospitalized minors. Texas Right to Life is the oldest and the largest pro-life organization in the state, and 20 years ago, we expanded our mission to protect patients' rights, including minors who are hospitalized, and there is pressure from hospitals and from doctors to withdraw that treatment. We have helped hundreds of families and protected vulnerable patients from newborns to those to patients in their 90s. As pro-life Texans, we are concerned about the systematic pressure to withdraw treatment, especially when there are legal questions and discussions of who is the proper surrogate decision maker to decide these life and death issues. We oppose the pro-euthanasia logic that says what happens in the hospital does not matter. The cause of death of the patient is ethically important, and that rush to withdraw life-sustaining treatment is something we adamantly oppose. We have seen time and time again that when there is legal confusion about who gets to make these decisions, who has the authority to withdraw treatment, that hospitals and doctors pressure the withdrawal of treatment, which occasions the death of vulnerable patients in Texas. Like in other cases that we've had very similar to this one, of baby Legend Johnson in 2023 and baby Wren in 2025. This is a too familiar story. We are concerned that this aspect of the Roberson case has been neglected, and want to highlight that unfortunately this is not rare, but something that our judicial system, that our governor, and that the citizens should be concerned about. We are thankful for the progress that the legislature has made in the area of patients' rights and respecting medical decisions from the proper guardians and parents to make for their children. However, coercion and a rush to withdraw treatment is too common around the state, and unfortunately, it's exactly what we see in this case in front of us. Thank you.
I'm Jeremy Newman. I'm the Vice President of the Family Freedom Project, and we work all across Texas to defend families, parental rights in particular, in CPS cases and other types of cases, and we work a lot in the legislature on bills related to those issues. I want to tell a couple stories to illustrate a theme to you guys. Back in 2019, we had a case with a family called the Pardo family. And in their situation, their 4-year-old son, Drake, had a lot of complex medical issues. He was regularly seen by the doctors in Dallas. And on one particular visit, they took him into the hospital. And there was among other things, there was a question that came up about whether he needed a more permanent G-tube installed. And the doctor who was assigned to visit Drake in that hospital wasn't coming. And the family ended up filing a complaint with the hospital against him. And then come to find out, shortly after that complaint was filed, that doctor called in the child abuse pediatrician at that hospital to review the case. That child abuse pediatrician never met the family, never met Drake, but then proceeded to refer the case to CPS anyway. And then commenced a multi-month battle where CPS came in and took Drake away from his family, and all on the theory that the family might go and find another hospital and trick the hospital into getting a G-tube that might be unnecessary. That was the allegation. And on that basis, they took him for multiple months. We fought that all the way to the Texas Supreme Court, and the Texas Supreme Court ultimately sent him home. The second story that I want to tell to illustrate a point that I'm going to come back to in a second is one that just happened last year. And so in case you were thinking that this is something that happened 6 years ago and doesn't happen anymore, this one is from last year. And this is Jackie and Juan Boatwright from Fort Worth, Texas, who took their daughter Evelyn into Cook Children's Hospital because she was experiencing seizure-like symptoms. And when they took her into Cook Children's Hospital, Cook Children's did an MRI. Within 2 minutes, 2 minutes of when they conducted that MRI, the radiologist at Cook Children's Hospital wrote in the medical records that he suspected them for child abuse. How many alternative diagnoses had been done in that 2 minutes? 0. That's the point. Because then they proceeded to call in the child abuse pediatrician. They then proceeded to kick the family out of the hospital. And they took Evelyn for 10 months from that family. Multiple other medical experts came in to explain the brain bleed that Evelyn had and the alternative causes that could explain that. And Evelyn ended up being sent home in the fall of last year. Now, a third story that just happened recently here in Austin is a family that we helped who took their child in to the local hospital to get an evaluation done on a growth that the child had. And the hospital said, well, you probably need to get it biopsied. They chose to get it biopsied at a different medical facility because they trusted the second medical facility more. Well, the first medical facility called CPS on them because they chose a second medical facility, right? And so the common theme between all of these cases that I want to draw out for you guys is the fact that when these types of things happen, what the family experiences is that they are presumed guilty of child abuse from the beginning, and everything that follows afterwards is then interpreted in that light. And the alternative diagnoses that are supposed to be investigated aren't investigated by the doctor. And when you put these doctors on the stand, what they'll typically tell you is, we're not investigators. CPS is supposed to do that. Well, then you put CPS on the stand, and CPS will say, but we're not medical doctors. The doctors are supposed to do that. And so you get all the way to the court, and nobody has investigated what actually took place. But the family still lost their children. And then if they do get their children back, the situation that family is in is that how are they ever going to trust medical facilities again? And especially if you have a child that has ongoing medical needs, now every time you're contemplating if you can afford to go to a hospital or a doctor to get medical care for your child, you have to call your attorney before you can call your doctor to figure out if it's safe to get medical care for your child. So the point I want to illustrate for you guys is that this is an ongoing systematic problem that's happening in Texas. So it's not just one case. It's not just from 5 years ago, 10 years ago, 15 years ago. It's a consistent, ongoing thing that's happening every day. Thank you.
Hello, everyone. My name is Brad Scalis, and I'll do my best to keep this short, but that's going to be hard for me because I have a lot of passion for what we're doing here today. That passion comes from representing parents who have been falsely accused of shaken baby syndrome. I'm here as evidence as their attorney. Just like Jeremy said, what's happening here in Robertson's case is not an isolated tragedy. It's a systemic failure. Because child abuse pediatricians in children's hospitals all over the state and really the country are still using shaken baby syndrome. They're still using it to destroy families. Now, my clients, these parents, they're not on death row like Robert, but they're experiencing the same nightmare of having their children taken away from them based on a theory. And that's what shaken baby syndrome is. It's just a theory. It's a theory that's never been replicated by modern science. In science, if you can't replicate something, then you can't trust it. And if you can't trust it, then why are they still using it? But they are. I think most people assume or think that children's hospitals and child abuse pediatricians are relying on the most modern medical science. The truth is they're not. They're not. And I think the public is slowly beginning to learn this one case at a time. And we are fighting these claims one case at a time, one family at a time. And that's what's led me here today. And I'm here today to tell you that it doesn't matter if they're using the terminology of abusive head trauma or shaken baby syndrome. They're still using it and they're still destroying families. And they meaning child abuse pediatricians in children's hospitals, they ignore medical evidence, they ignore medical science in order to continue using this theory called shaken baby syndrome. But I don't ignore the evidence in my cases. I don't ignore the medical science in my cases. And that's why we're winning these cases against this claim. Because we don't blindly accept their theories anymore. We don't blindly accept shaken baby syndrome anymore. And that's one of the differences between now and back then in Robert's trial, is that now we fight the hell out of it. We fight the hell out of shaken baby syndrome. And we get children home, and we get children back with their parents. The simple fact is that Robert did not get a fair trial. Not on the facts, not on the law, and not on the science, especially the science. But what we do now, it's not rocket science, but we do would prove his innocence. We certainly do not concede to their diagnosis. We get all the medical records, and not just some of them, all of them. We get our own medical experts, and here's the key, we get medical experts that are up to date on the most modern medical science. That's huge. We provide the type of defense that Robert never received but deserved under the Constitution. The fact remains is that there's parents all over this state that are going into children's hospitals, and the most modern medical science and the Constitution are not following with them. This year, 2025, I had a case come out of the very same hospital that removed Nikki Curtis's life support. That's Robert Roberson's daughter. The same hospital that removed Nikki Curtis's life support 20-something plus years ago. This very same hospital, this very same children's hospital, accused my clients of abuse in this recent case. And they used the exact same theory they used against Robert. But see, they call it abusive head trauma now, right? The same hospital using the same diagnosis, but missing key pieces of medical evidence. Another issue that we're seeing in their diagnosis that is identical to Robert's case, and that I see in my cases, in the recent case, is that none of these children have any neck injuries. But they're still working from the diagnosis of violent shaking. Nikki didn't have a neck injury. Nikki Curtis did not have a neck injury. See, that defies biomechanical science. But, you know, when you attack them on the shaken baby syndrome, when you attack them on the science, they don't sit there and think to themselves, well, maybe we're wrong. They just changed their diagnosis to blunt force trauma. They're doing the same thing in Robert's case now. They'll change it to blunt force trauma despite there being no external injuries or any substantial head injuries. It doesn't matter to them that the medical evidence doesn't support shaking or blunt force trauma. It doesn't matter to them, and them I mean the child abuse pediatricians in children's hospitals. It doesn't matter to them that the medical science doesn't support any of their theories. Changing the diagnosis is simply a strategy to them to confuse and misdirect. But it doesn't work on us because we've seen it over and over again. It's a playbook that they use, and we know their playbook, and that's why we're winning these cases. Again, shifting to blunt force trauma and ignoring biomechanical science is all part of a systematic playbook that they repeated, and they repeat it on autopilot. And the truth is that they're using this playbook to kill a man, to kill Robert. So to those that are fighting to kill this man on October 16th, I simply want to ask a question. What is the harm in giving him a new trial? Because if you're right about Robert, if you're right about the medical evidence, and you're right about the medical science, then what is the harm in giving him a new trial? The only harm I see, is not giving him due process and not giving him a new trial. Because if we kill this man in the face of this medical evidence and in the face of the medical science, it'll be a stain on our state that will never go away. Ever. And history will look back on us and say, what the hell were they thinking? If we kill this man with what we know today, right now, it will mark the end of modern times in Texas. And not because the world stops spinning, because we turned our backs on science, on due process, on justice, on the values that we hold, or that we claim to hold, as a democracy, as a civil society. Thank you.
This adjusted for me. I'm a little shorter than Brad. My name is Shelley Troberman. Thank you all for being here. I am a longtime local attorney. At this point, I've been practicing for almost 20 years. In that 20 years, I spent some of that time as a Travis County prosecutor. I spent many years doing exclusively criminal defense. And at this point in my career, I spend a large portion of my time representing parents in cases very similar to the Robertson case. I say that just to let the audience know that I've seen these cases from all sides. I've seen how they're prosecuted. I've seen them from the criminal justice perspective, and now I see them every single day, more on the CPS side. Robert Robertson's case happened in 2003. I can unequivocally tell you that the situation with false allegations of child abuse has gotten exponentially worse since that time. The reason for that is because a little area, well, if you want to call it a specialty, but there was a specialty created for what's called child abuse pediatrics in 2009. And when that happened, the allegations of child abuse went through the roof. It wasn't because more people began abusing their tiny infants. It was because we had a group of people whose sole goal is to look, find, bend over backwards, do gymnastics to create an abuse case where one doesn't exist. I can tell you that in less than 2 years, I have represented successfully and won 10 different false allegation of child abuse cases at the CPS level. The first stop on these cases is often what's called an adversary hearing, where the department is trying to make their case for why they should be able to remove children. If that first step is lost, it's very common for those people to go on to be criminally charged. And in the less than 2 years, I have had 10 of those involving allegations of shaken baby, abusive head trauma, non-accidental trauma. They have a whole ever-changing list of names that they call it. And we've won every single one of those cases. If that gives you any idea of the actual medical strength of the cases that they're bringing forward at this point. We have one of my now dear friends and families from the last 2 years that I think had to step away from the direct sun, standing right over here with their 5 beautiful children, whose child had a late onset vitamin K deficiency brain bleed at Dell Children's Hospital, which had been accurately diagnosed that way. And then somewhere between that diagnosis and a couple weeks in the hospital, the child abuse pediatricians decided that it was believable that this child suffered this major medical condition that had been properly diagnosed and had also somehow in that time period had the unfortunate luck of being shaken by his family, who was all together at this point. I could literally stand here for days and tell you stories that would blow your mind about the facts of these cases, but we don't have time to do that. Every one of these families whose cases that I have taken at the CPS level are families who I would bet my own life on their innocence. And then as we work through the facts of the cases with our oftentimes far more qualified medical experts, every single last one of them had a medical explanation that made 1,000 times more sense than a diagnosis of child abuse. To jump on what some of the other speakers have already said, they make the decision that they are suspicious for child abuse from the moment these people walk in the door, and they base it on a constellation of symptoms that for many years has largely been thought of to only have one possible cause. And I would challenge you to consider how absurd in medicine is it that a particular combination of symptoms can only be caused by one thing. It is medically false, it is contrary to modern medical science, and every one of these families could have been saved the trauma of what they went through, let alone had they gone on to be criminally charged, had the people in these children's hospitals done their job. It ranges everything from late onset vitamin K deficiency bleeds to causes like genetic coagulation factors to birth injuries to strokes. There are thousands of reasons that we see similar symptoms to what I see in every one of my cases and to what was used to convict Robert Robertson. We struggle to get medical records from the hospitals. CPS and the medical system make it difficult at every level, and these cases are extremely expensive and difficult to properly defend. But that is literally what it takes to save these families, and in the case of Robertson, what it would have taken to save his life. As we stand here today, Texas is this close to executing a man on a theory that is at best as shaky as it gets, and at worst, complete and total nonsense. And it used to be that these children, their lives were at risk by an improper diagnosis, because the diagnosis dictates what treatment they have going forward. If you diagnose it as abuse and it's something else, their lives are at risk. But based on the Robert Roberson case, it's not just the child's lives who are at risk, it's now also the parents' lives that are at risk from the moment that they walk into that hospital, if the medical professionals don't get it right. And I'm here to tell you right now, as a mother of 4 children, that every person standing out here, every person in every county in the state of Texas, because I handle these everywhere. It's not just 1 or 2 hospitals, it's all of them. They operate with a similar MO. It is terrifying to think that not only could your child die as a result of a medical mistake, but now so could a parent. Thank you.
Thank you for being here. My name is Josh Burns. 10 years ago, I was convicted of a crime that I did not commit in the state of Michigan. After my then 2-month-old daughter fell ill, my wife and I found ourselves face to face with a child abuse pediatrician who called Child Protective Services and accused us of shaken baby syndrome. Our daughter was taken from us and put into foster care with strangers. We were in a battle to prove our innocence and to fight for our parental rights. Since I was the last one alone with my daughter before she got sick, I was charged criminally with child abuse. My wife was allowed 3 one-hour visits with our daughter, 3 one-hour visits a week, and I was not allowed to see my daughter at all. After 7 months of civil court proceedings, my wife was able to get our daughter home. But that same day, I was given 1 hour to pack up my things and move out of our family home because I was still facing a criminal trial. I ended up being convicted, served 1 year in prison, and lost the first 2 years of my daughter's life. Finally, after a 10-year battle fighting for my innocence, I was exonerated and declared innocent last year, thanks to the tireless work of the University of Michigan Innocence Clinic and the Michigan Attorney General's Conviction Integrity Unit. 3 years ago, my family decided to relocate to Texas. Our belief was that Texas cherishes liberty, parental rights, and evidence-based science. But then I learned about Robert Roberson, a father on Texas death row who is now scheduled to be executed in 15 days. Based on the same scientifically unsound shaken baby syndrome hypothesis that had caused my family so much harm. I also have been made aware that Robert's parental rights were violated by the state of Texas and the hospital treating his daughter. Parental rights are vital to the integrity of liberty in the state of Texas and across our nation. We must ensure that the law protects parents who are falsely accused and whose families come under attack from a system that flips the burden and forces the parents to prove their innocence during investigations and agenda-driven diagnoses from child abuse pediatricians. In my case, we demanded a second opinion. The child abuse pediatrician covered up and sought to hide the second opinion because it did not fit her narrative. That second opinion offered medical explanations for my daughter's symptoms because no crime occurred. Robert's daughter, Nikki, was a very sick child. He sought medical care for her so many times. The system failed Nikki and Robert because no crime occurred. There are so many questions that need answers in Robert's case. And to answer these questions, we need the courts to intervene and order a stay of execution and a new trial, because we must hear all the evidence. This man was convicted using science and methods that no longer stand under the scrutiny of truth and justice. And I stand here today as living proof of that. Robert's life hangs in the balance. We must seek truth and follow evidence-based science. This seems like common sense. What harm is it in following evidence and seeking truth? This is foundational under our system of government. So today I urge all in Texas who have the authority to stop this execution to do so. Texas is watching. Our nation is watching. The entire world is watching what we do here. We must get this right because we do not murder innocent people. So let's follow the evidence and the facts and let the truth prevail. Thank you.
Good afternoon. My name's Andy Kahn. I'm Director of Victim Services for Crime Stoppers of Houston. I'm an ardent supporter of the death penalty. I helped push through bills that allowed capital murder for those who murder a child. I'm also responsible for pushing through policy for allowing victims' families to witness executions. Factually, I've been to 9 executions with victims' families myself, so I know exactly what I'm talking about here. Nikki Curtis was only 2 years old. Crime Stoppers is an organization rooted in protecting victims. We start with the truth. Her life was precious. Her death was tragic. And yes, she deserves justice. But justice for victims means ensuring that the right person is held accountable with reliable evidence and a fair process. If we rush to judgment, if we rush to punish without certainty, we risk betraying victims and surviving family members by not securing true justice. As a board member of Parents of Murdered Children and surviving family members of homicide, trust me when I say victims want to make sure that the person that murdered one of their loved ones is indeed that person, and that's based on fact and evidence. We all know that Nikki was extremely ill. Her medical records clearly show that. When such medical records, credible medical records doubt, the justice system has a duty to pause and re-examine. Capital punishment is irreversible, and executing someone in the face of genuine scientific dispute risks both killing the wrong person and most definitely undermining public faith in justice. Our state recognized this principle when it passed Article 11.073, the Change Science Law, in 2013, acknowledging that convictions secured on outdated science must be revisited. And Robertson's case is a clear-cut example of whether that direct test and whether we're going to actually live up to that responsibility. 2018, missing CAT scans, CT scans of Nikki's heads were rediscovered. Radiology expert reviewed them and concluded a single minor impact consistent with a short fall from a bed, not multiple traumatic injuries. This new evidence clearly undermines the state's trial, full of narrative and violence shaking and repeated blunt force trauma. Why it doesn't matter in Texas? Because we passed a law changing science. The law gives courts the authority and the duty to revisit convictions when new scientific evidence, and yes, there is new scientific evidence, and the law was designed to prevent wrongful convictions from standing in the light of evolving science. At Crime Stoppers, we developed what's called a needs program. We're the only entity in the state that recognizing that we have to deal, particularly law enforcement, with people who have been diagnosed with autism in a special and unique way. and they have to learn and recognize different expressions, different ways that people with autism act. 2018, Robert Roberson was diagnosed with autism. Yet at the trial, everybody said he was flat, he was dull, he was not interested, he had zero facial expressions. Jurors look at that. They see a defendant that just frankly is just sitting there, doesn't care, doesn't look, doesn't show anything. That plays a role into the decision. What the jurors were not told is that Robert Roberson was diagnosed with autism. Jurors need to see credibility, they need to see the deception, and that's what happened in this case, and they need to be made aware of that. If he's autistic, what appeared to be cold is simply just a fact of people who have been diagnosed with autism. Texas has been a national leader in forensic reform, passing the first junk science statute in 2013. Robertson's case is the clearest test whether that law actually protects people convicted on outdated science. If Texas executes him, we basically are undoing our own progress, and we're showing the entire world that our reforms are hollow. This undermines Nikki's legacy, because victims deserve a justice system that truly learns and improves. Crime Stoppers of Houston is not calling for Robert Roberson's release. We are calling for a new trial, one that considers all the evidence that was not presented at his original trial, including the CT scans, the autism diagnosis, and modern medical science. A new trial is the only way to ensure Nikki's case is fully understood, her story is honored, and her death leads to better protection for children. Executing in the face of doubt does the opposite. It silences questions, it undermines trust, and it leaves Nikki's case as a warning sign of injustice instead of a catalyst for reform. I asked our Crime Stoppers team, when I was asked to take a look at this, to put together, I asked them to take a deep dive into this. And I don't do this lightly. And so for me to come along and take a stand, people were saying, how can you take a stand like this? Because sometimes you got to take the stand and you got to do the right thing. And this time we're taking a stand. And it's time for the state of Texas to also take a stand. Give them a new trial. Let's see what happens. But in the meantime, you know, we got 15 days, and the eyes of the world are upon us. Thank you.
Good afternoon. My name is Doug Deason. I am a Republican donor. I've been confused by the Houston Chronicle as being a far-right conservative, and I've been accused by people on the far right of being a rhino, so I fit somewhere in the middle. But I am a conservative. I do believe in the death penalty, but only when it's a heinous crime and there's no question, there's absolute proof. Obviously, this case does not fit that description. I'm also a Ken Paxton supporter. Ken is one of my really dear friends. He has been for 12 years, and I've been a supporter all the way through. I'm supporting him in the Senate race against John Cornyn. And I feel that he's been misled by some of his attorneys at the office. I know it's hard for him to override them, but I know that he's looking at it and he's trying to figure out what the right thing to do is. And I think we all know what the right thing to do is. I could go through a lot of notes that I have, but I'm not going to waste anybody's time. I think what's important is that there's only one truth here. Was she shaken, as the state said during the trial, or was she beaten, as being claimed now? If she was a victim of shaken baby syndrome, then under our current junk science laws, Robert must be given a new trial because of how that hypothesis has come into doubt in the past 20 years. And the new claim is that Nikki was beaten so viciously that she died. This is demonstrably false. If we know anything from the CT scan, which, by the way, as was stated earlier, the jury never saw, and the photos, it is that Nikki had no significant bruises, no significant lacerations, and not so much as a single hairline fracture anywhere on her body. And I want to demonstrate that. And we will pass these out later if you want to see them. But the state has claimed that a Texas jury convicted Robertson of beating his 2-year-old daughter to death, and courts repeatedly rejected his efforts to upset his conviction and sentence. So that's our state's claim right now, state of Texas. Here is a picture of Nikki. It's not the ones that have been used in courts, not the one that the Attorney General's office uses today. This is one that was taken after she died during the autopsy, before the autopsy. Here are more pictures. There's no bruising, there are no lacerations, there's no damage. So what they're using are post-autopsy photos where they've gone in, doctors have gone in with scalpels and cut into her. So it's completely false. That's what was used as evidence. So I want to ask. I think Robert deserves justice just like we all do, proper justice. This is aimed exactly, directly at our 9 justices on the Court of Criminal Appeals. Justices Keel, Richardson, Urey, Walker, McClure, Parker, Finley, Newell, and Schenck. Please grant Robert Robertson a new trial. Thank you. Now, if you have any questions, we've got Gretchen Swin is here, Robert's attorney. She's been on this for many, many years, and she can help us answer any questions you may have. Thank you.
Hello, I don't have any prepared remarks, and I'm truly humbled and really overwhelmed by what you witnessed here. This was a gift not just to Robert. It was a gift to the state of Texas and the integrity of our judicial system that these brave conservatives have been willing to look past a lot of misinformation that's out there and study this case and use reason, because it is extremely hard when you're talking about the death of a beautiful young child. And that's part of the whole terrible legacy here, is that we kind of lose our mind if we're faced with something like what happened with Robert and Nikki. You see a beautiful 2-year-old child unconscious and turning blue, and you want to blame somebody. And it's a lot easier to point to the odd-looking autistic father who's poor and lives on the edge of town and is making his living throwing paper routes and say, oh, he looks off, than it is to dig into the child's medical records, to question superficial science, and to demand logic in the face of a tragedy. So I'm starting to give a speech, and I don't want to do that. I really just want to say how grateful I am on Robert's behalf that this event has happened. And if you have questions about the facts, because there is so much misinformation, I'm here for you. Yes, sir.
I'm Dr. Thompson. I happen to be an international physician and the professor of health.
Can you...
I said I'm Dr. Thompson. I happen to be an international physician and the chief editor of health at the relevant academy. So we work with the crime stoppers, people, website. I mean, this is where the best persona was there, so I thank you for coming. We don't take death of proven issues very lightly. The first point I'll make after asking my question is it is better to get a criminal go than still an innocent person. That doesn't mean that children don't have rights. So, as a physician who happens to be doing medical journalism and like doctor, we can have the death of a child without physical features or symptoms from the outside. Because you shake a child and there is no trauma on the neck or the spine doesn't mean that they are not internal victims. So the point we want to make is, are you very, very clear that you have really considered all of these and really called experts, are really experts who are also looking at the rights of this child, and it's not because they believe somebody that you have an interest in or somebody that, somebody has convinced you by the side. That's my thing.
Okay, I think the question was that have we consulted with legitimate medical experts
Yes.
instead of just looking for some way to help a client?
Yep.
And I want to first point out, which I think several of the speakers did, that when Robert was accused in 2002 and lost his beloved daughter, he was appointed a lawyer, as a poor person has a right to, who refused to entertain his own claims that he had done nothing to harm his daughter. Then the lawyer insisted that this was a classic shaken baby case, but Robert was just too impaired to have known what he was doing. That was the defense, which, by the way, is not a defense. Right? And so there was no adversarial process. Everybody in that courtroom was looking at Robert as someone who was guilty, including his own defense lawyer. There were no medical experts put on the stand by the defense to tell the other side of the story. For 14 years, Robert had no lawyer willing to look at anything else. They just kept, collecting some, funding from the state, filing these empty appeals, and never listening to their client who kept writing these pitiful letters. Dear judge, would you please give me an attorney who will represent me? 14 years, right? Robert is only alive now because a group of us volunteered. And I've been working on this case now for nearly 10 years, and most of that is entirely pro bono. I didn't have any preconception about shaken baby in 2016, but I started studying it. And I learned what you learned. And I would love for you to add to that, because what is happening today is there's supposed to be what's called a differential diagnosis, where you consider everything else before you rush to abuse. When Robert was accused, it was the exact opposite. Abuse is the first explanation, and you don't need to look at anything else because pediatricians were being taught, you see these three things inside a child's head, you can presume they were shaken. That has been completely reversed, and in fact, to date, there's no science to show shaking can cause any of those symptoms. That's where we are today. But they still make this diagnosis. Do you want to jump in here on this point?
I just had, if I understood the question correctly, and correct me if I'm wrong, was the question whether or not we seek the opinion of other qualified medical experts? Was that the question? Okay, well, that's one I can answer. I will tell you that in the many cases that have been exactly like Robert Robertson's case, the only difference was we wanted at such an early level because these were people who had funding. It is astronomically expensive to hire the best medical experts in the country, many of them, to come testify at any kind of a hearing. Extremely expensive. So if you're poor, it's not happening. The courts aren't appointing these people. But for my clients who have managed to scrape together the funds or have the money, the experts that we have brought forward are far more qualified than the ones operating on the other side of the case. If it's a child abuse pediatrician that's 1 year out of residency, I'm bringing a guy from Michigan that's 35 years out of residency, working at a major children's hospital in another city. So I can unequivocally tell you on these cases that have been won at a much earlier stage, or the way that a criminal case like Robert Robertson's case in a perfect world should have been managed by an attorney that knew what they were doing, is absolutely. You seek the opinion of more qualified experts with more years experience that often testify for the other side, but in your case, they're testifying for you. So I know that there's the jump to think, oh, defense attorneys are just out looking for, some loophole. That is unequivocally not true. And I have I have more than 10 cases, but 10 in the last 2 years where judges have literally, including the gentleman who's standing right here, stopped the hearing halfway through and said, I don't want to hear anymore. I don't know what's going on in Austin, but these children need to be returned immediately. If Robert Robertson had had the benefit of that kind of a defense, we wouldn't be here today. So the experts exist. They don't exist in the same hospitals. They don't like to testify against each other. But Dell Hospital is no different than Cleveland Children. I mean, they're all equally qualified, regardless of what state they come from. Their medical education is similar. So to answer your question, absolutely. This man wasn't given that opportunity factually, legally, or any other way. And but for people like this, we wouldn't even be standing here still begging for his life. But as long as he's still living, we can still keep fighting.
I just wanted to add to that the medical experts that we're using to win our cases and get children back, some of those experts are the same experts that were on the team that Gretchen Sreen is using for Robert's case. So we're definitely using experts that are qualified, specifically in areas of pathology and biomechanical engineering. So that needs to be noted. Thank you.
And I will underscore here that Robert had no defense, no experts, no counter story, nobody even talking to him at the jail. Today, we have this all-star roster of highly credentialed experts who are so outraged by this case, many of them have worked for free. Robert's case is exceptionally outrageous, and yet none of their detailed reports about Nikki's chronic health issues, about her undiagnosed pneumonia, about the respiratory suppressing medications that were prescribed to her by the same doctors who missed the pneumonia the very last week of her life, Phenergan and codeine for a 2-year-old who's having breathing issues. None of this, and you've heard over and over again the mention of the CAT scans. Nothing about the CAT scans have been discussed yet in this case, not at trial, not in any court decision. This is exculpatory evidence because it counters this whole narrative that there was some beating, even if there wasn't shaking.
Do you have a question?
There are many Republican elected officials and Republican advocates who are in support of everything that has been said here today, and I think we will start to see more people speaking out. And I don't know if Rob wants to say.
Yeah.
Obviously, Brian Harrison, who's one of the most conservative representatives in this state, possibly in the country, is very supportive of this. We were on the phone with him. Everything that I said, he and I have discussed, and he's in 100% agreement with me, with Lacey, with State Representative Paul, and others. So nobody's trying to pressure Attorney General Ken Paxton or Governor. The governor could stop it for a month. Nobody's trying to pressure them on that. They don't respond well to pressure like a lot. Most politicians don't. All we're trying to do is, one, get the facts out. Two, reach the Court of Criminal Appeals directly to them and say that, hey, you've got a lot of cover. There are a lot of Republicans in this state who believe that Robert deserves another trial. And that's simply the purpose here. I wish they were standing right there and we could all go shake their hand and talk to them eye to eye, but they're not. And they're probably not watching now, but maybe they'll catch little bits of this on social media or whatever and understand that they have nothing to fear. The people who are the loudest are the people who want Robert executed tomorrow, and they're wrong. They haven't seen all of they're smart people, but they haven't seen all the facts. They haven't seen this side of it. Anything else? Anybody else have a question? Yes.
Okay, legal strategy. I heard that. And I think you mentioned the heroic effort of the lawmakers this time last year. And, you know, anybody that followed that, I mean, that was a Hail Mary miracle that was based on people studying this case and being outraged that Robert hadn't gotten relief because it's their law, and yet the burden seemed to be so ridiculous considering the evidence that had been amassed. They saved his life by trying to subpoena him and have him come to the Capitol and testify, and that was then thwarted, but it stopped the execution. But now there's law, it can't be repeated. You know, it was a separation of powers fight, and I think both sides kind of won something. The lawmakers were told your subpoena is valid, you can subpoena anybody you want, but you can't interfere with an execution date. And the problem is, an execution date has been set in this case, and the clock has been ticking since July. Meanwhile, there are two massive habeas applications pending before the Court of Criminal Appeals, along with a motion to stay the execution, which means stop it, along with motions to reconsider the past denials from last fall. But these habeas petitions are supported by yet more new scientific evidence of the junk science and of Robert's innocence that has been amassed since October. And I'll give you one example, because there was a question suggesting maybe these weren't the best experts. Michael LaPosada, formerly of Harvard Medical School, full professor there, came to Texas to head the pathology department at UTMB, a very prestigious institution here in Texas. Michael LaPosada is one of the leading experts in the world in bleeding disorders and how they can be mistaken in a sick individual for trauma. And remember, Nikki's fundamental symptom was bleeding outside of the brain inside her skull. And back in the day, that was shaken baby syndrome. You know, we don't look at anything else. Well, now we know there are a host of naturally occurring phenomenon that can cause this. One of them being a bleeding disorder that arises from an infection like pneumonia. He just looks at her blood tests that were done in the hospital and says all these signs. She had significant DIC, which is a bleeding disorder. And so as the CT scans show very little blood outside of the brain. 2 days later, during the autopsy, when they cut into this child and peel back her scalp, there's a lot of blood. How could that have been caused by inflicted trauma when it wasn't there 2 days ago? The answer is that the hospital triage to try to reverse her condition, combined with this pneumonia that had not been diagnosed, that was progressing to sepsis and causing this bleeding disorder, caused this extra bleeding to continue over the course of 2 days. You can't say that's proof of an inflicted injury from 2 days ago. It didn't exist. Michael LaPosada, Google the man. This is not, yes, sorry. And the legal strategy is we're waiting on the CCA to grant a stay so they can continue to deliberate, or to grant relief, which is a new trial. You've heard that over and over again. That's the request, a new trial. And if the objective medical evidence that still exists, they think is strong enough, they can try the case. We think we can prove his innocence.
Are there any other questions? Okay, come up closer so we can hear you if you don't mind.
Every good prosecutor is looking at motive. And I'm sure there was have presented something to do the report. So if they need, what is your defense against the motive for the accusation?
For motive?
Because every prosecutor never presented any motive.
There was never a presentation of motive. There is no motive. It's absurd. So let me just wrap up here real quick and say that I visited on Labor Day 24. I visited Robert with Bobby Lumpkin, who's now our executive director of the Texas Criminal Justice Department, the prison system. Before that, at that time, he was the director of prisons, with Brian Collier, who had his role before. And Bobby and I went and we spent an hour with Robert. And Robert was, a humble, man. He is not, a high IQ person, but he is a sweet, person and a sweet man who loves his Lord and loved his daughter, and he loves his daughter now. And obviously she can't be returned to him, and he spent well over 20 years in prison. In any rational, sane court, this would not be capital murder. Even if he was guilty, it would be at best be manslaughter, and he would already be out. But, for whatever reason, a lot of prosecutors, they want the feather in their cap. They want scalps. They don't want losses, and they want big scalps. So that's apparently what was going on here. Plus, if you think about it, Anderson County is a tiny little county. They really don't have the expertise or the ability to try a complicated case like this. So, we really need to look at, should we move cases like this to bigger counties where there are more access to better attorneys, better prosecutors, and better judges, frankly. But Robert is a good man. Bobby and I, we prayed with him. We walked away. I looked at him. We were both crying. And he said, he doesn't belong here. And I said, no, he doesn't. And that's how we feel, and we hope that the CCA will agree that he at least deserves a new trial. Thank you all for coming. Thank you, Lacey, for putting this together. Thanks to all the witnesses and speakers today. We appreciate it all, and this, it's pretty hot, pretty uncomfortable, so thank you.